environment of the waters of the state. Also, again, quoting from this section, it is the public policy of the state to preserve the waters of the state as free and common fishery. The health, welfare, environment, and general well-being of the people of the state require that the state restrict the uses of its waters and the land thereunder for aquaculture. And in the exercise of the police power, the waters of the state and land thereunder are to be regulated under this chapter. And now there are a number of provisions in chapter 20-10 that I'm not going to read to you. I'm just highlighting certain portions. Does anyone want to talk about anything in this chapter, what our authority is, the provisions that I've just read?
Just, Madam Chair,
Yes, Mr. Gomez.
just going through the Red Book, I just want to make sure I've been using the Red Book mostly, not the Rhode Island statute that you just read. They're pretty much, the Red Book is very much compliant with what you just read, is it not?
Yeah, that's my view. So what I read to you is from Declaration of Intent and Public Policy that is the reasoning, I guess, behind the authority given to the CRMC to award aquaculture leases. And so as I view it, and we can check with our legal counsel, the regulatory standards that we need to review in the Red Book are the expression of that intent in public policy. In other words,
Yep.
to measure whether or not we're meeting this best public interest, we go to the specifics in the Red Book.
Thank you.
That's correct. And Don, specifically section 20-10-3 gives the CRMC authority to grant permits for aquaculture pursuant to the regulations that are promulgated in the Red Book.
Thank you.
Any other questions or discussion about the statute? Okay. So good segue from Mr. Gomez. And we, under the Red Book, we have to ensure that the applicant has met his burden on a number of factors. And that's 1.3.1 A of the Red Book, and that's category B requirements. As you've seen in the post-hearing briefs, these are iterated, but I will read them, not in full, but somewhat paraphrasing of this, and we can have discussion then. So under this section, the requirements for category B assent are necessary data and information for the purposes. Hold on. All persons applying for a category B assent are required to 1, demonstrate the need for the proposed activity or alteration. B, demonstrate that all applicable local zoning ordinances, building codes, flood hazard standards, and all safety codes, fire codes, and environmental requirements have or will be met. C, describe the boundaries of the coastal waters and land area that is anticipated to be affected. D, demonstrate that the alteration or activity will not result in significant impacts on erosion and or deposition processes along the shore and in tidal waters. E, demonstrate that the alteration or activity will not result in significant impacts on the abundance and diversity of plant and animal life. F, demonstrate that the alteration will not unreasonably interfere with, impair, or significantly impact existing public access to or use of tidal waters and or the shore. G, demonstrate that the alteration will not result in significant impacts to water circulation, flushing, turbidity, and sedimentation. H, demonstrate that there will be no significant deterioration in the quality of the water in the immediate vicinity as defined by DEM. I, demonstrate that the alteration or activity will not result in significant impacts to areas of historic and archaeological significance. J, demonstrate that the alteration or activity will not result in significant conflicts with water-dependent uses and activities such as recreational boating, fishing, swimming, navigation, and commerce. And K, demonstrate that measures have been taken to minimize any adverse scenic impact. Any questions or discussion of these requirements under the Red Book for category B ascents?
Madam Chair, I do have a question.
Okay, Ms. Reynolds and then Mr. Gomez.
For all of those requirements, do we need to make a positive finding? Or can we do sort of substantial compliance that it complies with most of those category B requirements?
Mr. DeSisto?
Well, I don't really see a distinction, Patricia. If you're going to make a positive finding on it, that means that you have to, when you weigh it out, there's more positive, for lack of a better way to explain it, there's more positives than negatives. So to me, if
Okay,
there's
so then
substantially,
so some of those things maybe we feel we can't make a positive finding on, but if the overall, if we find overall that it's consistent, it's okay. Because I'm just trying to judge how compliant it needs to be in order for us to recommend.
what you have to do is you have to make positive findings of fact on all of those factors that apply to this application.
Okay.
In other words, if you can't make a positive finding of fact on one of the factors, that's fatal to the application.
Okay, thank you. That's what I needed to know.
Yes.
Mr. Gomez?
Yeah, the last issue, the scenic impact, I thought that was a category that CRMC really didn't get involved in. And subjective, scenic impact is just extremely subjective. I look at the initial wind turbines and call them ugly, and in a month I think they're fine. You know, it changes with time, and I'm not sure what the definition of a scenic impact is.
If one of the I'm sorry, go ahead, Madam Chair.
Okay, I just wanted to point out that all we need to find is that measures have been taken to minimize it, as opposed to saying we think this is scenic or not, because I agree with you. I think that's highly subjective. So we just need to look at, did the applicant take certain measures to reduce the overall appearance, such as like low profile cages. All right, Mr. Murray?
Yeah, it just observation. It seems that the repetition of the word significant is significant, and that's the judgmental aspect. It's not that there'd be no conflicts per se, but it's whether or not they're significant or not. And I guess that's, well, I mean, it's repeated in almost every one for a purpose, I take it.
Yeah, and you're just talking in general throughout these requirements that the standard is that significant.
Right.
Yeah, that's the threshold for a number of these. Yes, I agree.
My only final point on it, just to follow up, is that, you know, some of these standards might not apply. For instance, where is it? Historic and archaeological significance. If there are no historic or archaeological components to the application at hand, you know, that's something that you make a finding of fact on, that it's inapplicable to this type of an application. So I think that's one of the things you have to determine also.
Okay, thank you. Any other comments, questions about the category B requirements? Okay. Another standard which is also found in the aquaculture provisions in the Red Book that there's been much discussion on is this, the so-called 5% rule. And I just want to read to you where it's presented in the Red Book. Just a second. This is where I need Jim Boyd, but okay, this is,
Madam Chair, that's section 1.3.1K 4F. It's under the prohibition section.
and there's another provision too at 520. So I'm just going to read both of those, and thank you. I can always count on you to get the specifics. In the coastal, this is 4F. In the coastal salt ponds, the area occupied by commercial aquaculture shall not exceed 5% of the total open water surface area of the coastal pond below MLW. So that's one place where it appears. It also is at subpart 520. The maximum area occupied by aquaculture leases in the coastal salt ponds is 5% of the total open water surface area of the salt pond below MLW. This limit is established based upon the current knowledge of ecological carrying capacity models. On this, I think everyone agrees that there is a 5% rule, and there's some discussion about what that rule represents. In the section I just read, it says that it's based upon ecological carrying capacity. And there's been some suggestion that it might be beyond that, social carrying capacity. So I guess what I would like to do, I have a view of it, but I'd like to ask Dave and Ben what that 5% represents. Mr. Butel?
The 5% rule was, as you read, for the overall amount of aquaculture for a coastal pond in mean low water. It was based on the ecological carrying capacity knowledge at the time. I think you all heard Dr. Byron and Dr. Rowe talk about how 5% is significantly below the ecological carrying capacity. So it is based on ecological knowledge, but the fact is that it has been used as a social carrying capacity. That has been how it has been applied.
Okay. Mr. Getz, you have anything to add to that?
Yeah, no, it is regularly referred to as a de facto social carrying capacity, but nowhere in the Red Book is it referred to as such. In the very beginning of the K chapter for aquaculture, K1A, it says that CRMC the council recognizes the possibility of setting scientifically defensible limits on aquaculture leasing in any particular water body. And I believe that the 5% rule falls under this kind of policy statement, and that it's scientifically defensible. Current knowledge shows that it might be more like 40%. However, there's been no intention to change the 5%. I think because there's been at least a de facto recognition that it is a social carrying capacity, which is something that has been studied, but I don't think it's been specifically defined to be 5% or above.
You say, as I'm understanding both of you, that it has been understood as a de facto social carrying capacity, the 5%?
Yes, yeah, and that was, I think, the result of Dr. Byron's study. It is, again, it's not mentioned or referred to as a social carrying capacity in the Red Book.
And just to clarify, the 5% represents a ceiling, so you can't have more than 5% of a particular coastal pond that's occupied by aquaculture leases. However, if you're below the 5%, you could still be denied an aquaculture application if you don't meet the category B requirements. Is that correct?
That's correct, yes.
Does anyone else have questions about the 5% rule? Want to discuss it? Mr. Murray, you're on mute.
I wonder if the staff would opine as to whether they view the 5% as a very conservative limit to capacity.
Very conservative limit to, did you say ecological or social carrying capacity? I didn't hear the question.
I don't think, I prefer it. The social carrying capacity is kind of an amorphous term and not agreed to or defined by probably even the people assembled here. I just wonder if the 5%, I guess, is an accommodation on a conservative basis for aquaculture in an effort to minimize conflicts with other uses of the coastal resources, ponds.
So the number was originally derived from using data from a New Zealand study that I think Bob Rowe with the aquaculture working group did a kind of a initial study of what level of aquaculture would not have an effect on the ecology of the ponds. 5% was kind of anyone's best guess at that time. There was further study that was done after that, determined that number could actually be much higher. But the members of the working group, which was a multi-stakeholder group, agreed that 5% was a number that all parties could live with. I would ask Dave Butel to elaborate on this, as he was, I believe, party to some of those conversations.
The working group did agree on the 5% rule based on the ecological knowledge at the time. As Mr. Getz just mentioned, subsequent knowledge came in that the ecological carrying capacity was significantly higher than 5%. But the aquaculture working group agreed to continue to use the 5% amount for regulation.
Mr.
Madam Chair,
Gomez.
I think I talked too much, but based on the presenters' objections, which we heard many, it would appear to me that the social or recreational capacity, which I don't know what that number should be, but has certainly been exceeded and probably will get further exceeded. And I just want to be able to, in my own mind, to separate the social carrying capacity versus the aquaculture carrying capacity. So when I look at this question, I'd like to look exclusively at the 5% rule. Is that correct, or do we need to do something in between?
You want to look at the 5% rule only as it applies to ecological carrying capacity?
Yes,
Yeah.
yes.
Yeah,
And even given that it appears that the recreational carrying capacity based on presentations of objectives is probably exceeded. Number of moorings, number of skiers, number of go on and on and on. So there's a conflict there. Which is evident because of the presenters that objected. And the 5% rule to me applies to the aquacultural permit within that pond. And that's what I would like to make my judgment on, as opposed to the fact that the other uses interfere with that capacity or apparently interfere with that capacity, 5%. And I don't know. I mean, I just don't know. I tend to favor the 5% rule because it's so conservative. And I think all the conditions are pretty much met relative to the water quality, the carrying capacity of the oyster farm or the shellfish farm. It seems like a pretty good spot. It's tucked in more or less out of the way, and then we have the town noting, in fact, it passed, I guess, an ordinance stating the high-speed craft need to set back from the shoreline, which further reduced the, in my mind, the social recreational carrying capacity of that area because of the setback. So I've taken that into consideration also, but I'm just trying to separate out the social carrying capacity, the number of people that want to use that waterway versus, a small section of that being identified within CRMC limits of the 5% rule, if not any of that makes sense.
yeah, I understand where you're going with that. For me, the way that I'll view it on the 5% rule is that it represents ecological carrying capacity. I think it's ambiguous as to whether or not it represents social carrying capacity. And so I'm going to try not to base my decision on 5% as applied to social carrying capacity, because it seems somewhat arbitrary to me to just 5% equals okay. I'm going to focus on the very specific category B requirements. And I'm satisfied that we don't go over 5% for the pond. So that, per our regulations, appears to satisfy the ecological portion.
And that's what I'm in agreement with. Yes, thank you.
Okay, good. Anyone else want to talk about the 5% rule or have questions about it? Mr. Boyd.
Madam Chair, just to the point of discussion just now on the ecological carrying capacity, if I may, the very first policy in the aquaculture section, 1.3.1K 1A, speaks to the fact that as any human activity can have adverse environmental effects, the council recognizes the possibility of setting scientifically defensible limits on aquaculture leasing in any particular water body. The CRMC also recognizes that in the framework of adaptive management protocols, research into the ecology of coastal waters and our understanding of ecosystem carrying capacities is constantly evolving and improving. So that policy speaks essentially to the ecological carrying capacity and in no way mentions the societal carrying capacity here. And so the 5% rule is entirely focused for purposes of the regulation on the ecological carrying capacity.
Okay, thank you for that clarification. All right. Anyone else, or are we done with this topic? Okay. There has also been identified and discussed with the expert testimony, this section 4.8 of the South Kingstown Boats and Waterways Ordinance. The ordinance itself is not a CRMP regulation or requirement. It's been identified, I believe, to demonstrate whether or not there's more or less conflict with existing uses. So the way, I'm going to read it and then tell you how I view it, and we can get council to weigh in on this. But section 4.8, which governs water skiing, swimming, and personal watercraft, and then in parens, jet skis, etc. Subpart 1, no water skiing will be allowed in the Narrows, Upper Point, Judith Pond, Potter's Pond Channel, or in the designated areas of anchorages or moorings. No water skier or his or her boat shall approach any stationary or moving object closer than 200 feet, except as may be incidental to starting or finishing a run, nor shall any water skier ski within any designated channels. So that has been discussed by both the applicant and the interveners. There's also subpart 6, which has been identified for context, which is no person shall operate a personal watercraft within 200 feet of swimmers, divers, shore, or moored vessels, except at headway speed. So I just want to ask first, Mr. DeSisto, if it's correct that this local ordinance is not binding upon this subcommittee, but it may be relevant in our evaluation of conflicts or how the proposed farm fits within the cove.
That's correct, yes. Not binding, but certainly relevant to your discussion.
Okay, thank you. Anyone want to comment on this, have a question about it? Okay. All right, I believe that sets forth the general legal authorities that we're working within. Have I missed anything, Mr. DeSisto, or any subcommittee members that you'd like to add?
No, I think that was an excellent summary to get the deliberations going.
Okay. And again, there's other provisions of the Red Book and of the statute. I haven't read everything in its entirety, but it's my opinion that these are the most relevant policies and standards to focus on for our deliberations. Okay. So we have before us two configurations. So the proposed farm came in as configuration A. And then through discussions with our aquaculture coordinator and feedback from stakeholders, the applicant agreed that there could be this configuration B that takes off some of the western edge of, I'll call it a rectangle or an initial rectangle. And then the configuration B is now what we have been referring to as a polygon. So the preference, as I understand it, from the staff report is for configuration B, but we still have those two in front of us for discussion. Mr. Butel, is that correct?
That is correct, Madam Chair.
Okay, anything else that you want to add on the configuration B?
The only thing I can add is that a rectangle from a farmer's point of view is easier to work than a five-sided polygon.
Okay, thank you. So let's talk now about testimony, admitted documents that go to, I'll just put out the first topic, what activity occurs in Seeger Cove or the pond as a whole. So, I want to kind of get together what we believe, according to a preponderance of the evidence, what is that activity that we're going to have to look at to determine any conflicting uses. So can I just ask, I'll just start with you, Mr. Murray, being the South Kingstown representative, if you want to comment upon what you viewed as the activity, either as to type or frequency or both.
Well, I think in general, Potter Pond is a more quietly used pond than other salt ponds that have are more readily accessible. There was a bit of discussion about rights of way providing access to the pond, but I think none of those rights of way really are have supportive parking, for example, to make the general public doesn't have as ready access as people who live on the pond. And Water Street, for example, in Matunic, there's been a dispute as to whether that's a public access or not. I think the people that live in Matunic Point have rights to it, but there was a big dust up last summer, as a matter of fact, over that probably isn't resolved. I've got probably almost 60 years association with living in Matunic. I grew up at Mary Carpenter's Beach Meadow. My family still owns a house there. I live in East Matunic, and at this point for the last 25 years. And I've used the pond quite a bit. I don't, I've actually water skied in the pond, although not in several decades. And it seems to me that that's of the use characteristic of the pond. I think water skiing is probably a smaller slice of the pie than other uses that occur there: fishing, shellfishing, kayaking, for example. And so, I don't think the use characteristics are as dramatic as some folks had said during the course of the hearings, or as limited as the applicant's photographic record. Probably somewhere betwixt and between is what, and it's weather dependent, time of the year dependent. But I think it's a fairly quiet pond if you compare it to others in the state.
Yeah, I viewed the applicant's photographic record as limited, obviously, because it was a snapshot in time, noon hour for a period of time. And it's hard to draw conclusions about whether or not there was activity at other times during the day. So I think it's some evidence, but it's on the more limited evidence side, in my view. I thought the collective testimony of those who live on the cove and use the cove and the pond, in my view, the preponderance of the evidence was that there is regular activity on the pond. And it's a variety of different uses, the water skiing, and more passive recreational uses of the kayaks and small craft and paddle boarders and that type of thing. But I did come away with the understanding that there is regular seasonal use particularly in the summer, more higher regular use of that cove. And that there's certain patterns that have developed as far as the fast lane and the slow lane, where the recreational, more passive recreational users are going closer to the farm area. The deep middle is, if you're going to have water skiing, that's where you'll see the water skiers. So that's what I got from the kind of collective testimony on that. Mr. Gomez, would you like to comment?
Yeah. Again, the water skiing seemed to come up quite frequently. When I put that with the relevant ordinance, it seemed to have minimal impact. And at some point we were talking about maybe one more skier could use the area. The passive, if you will, kayaking and things like that, there may be some impact. I had toyed with the idea of maybe moving, I think it was 10 feet from mean low water or something, the edge of the pond. There was testimony that said transit lanes through the farm and the area along the shore would accommodate the kayaks and things. The one question maybe that we should discuss is there were several parties that thought the farm restricted access to the cove because of its location and bringing in a boat from the main body of the pond. And I'm not sure if that's really true or not, but there were several people that said, trying to navigate, especially a sailboat, especially a small sailboat, into the pond might be impacted by the farm. And I don't know if we want to get into it now or not, but there might be some modifications. One of the restrictions on the pond is that you'll flag the corners, but the deep water part of the pond is bottom shell fishing. And I'm not sure we need flags right to the edge of the bottom shell fishing. Maybe the flags could be back a little bit. So just some thoughts that maybe we can discuss later on that. So I don't see a major impact to the recreational use. I just, people deal with kayaks and small canoes and things like that around the ponds on a regular, around the farms on a regular basis. The impact to the high-speed water skiing, if one follows the ordinance in that location, seems to be minimal. And that would be my thoughts.
Okay. Ms. Reynolds, would you like to comment upon activity in the cove and pond?
I'm happy to follow Don because a lot of what he says I also agree with. For me, there was obviously a lot of very heartfelt testimony from lots of people who live near and use the pond. And for me, there's clearly no doubt that having the aquaculture there impacts water-dependent uses or activities, letter B in the requirements. But to me, it's really the extent of that impact, how significant that impact is. So with the farm there, to me, it prohibits all recreation in that specific area. It's not safe to swim. Paddling is probably not a good idea. And clearly the any kind of motorized sports is not safe in that area. So it does preclude it. But because of the setbacks for the zoning for the town, that limited area becomes even less significant to me. And also the fact that there are very few opportunities in that area to water ski anyway, also again, makes that a bit less significant to me. So I think that there is a way for all of these uses to be balanced on the pond that the existence of the aquaculture could stay, and then because of the limited impact to all of the other water dependent uses, they can continue to occur on other areas of the pond. So for me, I don't find the farm being there, the proposed farm, to be a significant impact on recreation.
So let's, because it's been brought up a couple times now. Well, maybe I should ask my vice chair if you want to comment first, and then I want to talk about the buffers.
I will, Madam Chair. First thing, unrelated but related, when you made your introduction, you thanked staff and everyone that participated was almost verbatim for what I had, but I just wanted to add, I want to thank you as our chair, because this was a difficult application and procedure, putting everything together, allowing everyone to be heard. So thanking everyone that you thanked, but I want to thank you as well for running the meetings. Now to the question at hand, similar to you, when I look at the evidence put forth by the applicant, and I had in quotation marks here, and it was something you said as well, it's a snapshot in time. So we look at that snapshot in time as it relates to the evidence that's been put forth by the applicant. But what I needed to rely on were the local residents and recreators who have more of an intimate knowledge of the cove and its uses. You know, Vin has been there, he's done things on the water. I didn't have that benefit, so I rely on the local residents and everything that they said. Staff report way back said, you know, the significance of the effect is debatable. So that's the whole purpose of the hearing. We're hearing both sides over here. Similar to what's been said, I do feel that placement of that aquafarm there creates an issue. And my concern is that placement of the plan there will compress the water activity to the center of the pond and create more of a safety issue. So maybe unlike some of you, and I don't mean this downplaying what you guys said, I find that there is a safety issue, and that's what's going to sway me. Maybe showing my hand here, you know, as counsel said, that a non-positive factual finding is fatal to the application. And when I look at everything, I do feel, and I'm of the opinion, that there is a significant impact on existing public use, water use, recreational activity, and that. So while I apply all of the evidence, expert lay testimony and all that to each and every criteria that you succinctly delineated for us, and I think every one of them is met, except I do feel, and I hold the opinion that the evidence to me reflects that there is a significant impact.
Thank you, Mr. Koya. Okay, so that's a good segue. So back to the buffers, because I've heard a couple times now that the buffers already significantly restrict what can be done in that area. And I want to make sure that we're all on the same page as to what can be restricted in the 200-foot buffer. So the prohibition of the 200 feet relates to water skiing. So this is water skiing only within the 200 feet. If I'm reading this correctly, well, water skier or his or her boat that's towing the water skier. And I want to make sure, Mr. DeSisto, that that's how you view that ordinance, that it relates to one of the uses of the pond.
Correct, yes.
Okay. And then you have the water skier or his or her boat have to stay away from the stationary or moving objects. So if you have 200 feet, the farm occupies 200 feet out from the shore, then anything that's stationary within that farm, you would have to measure another 200 feet into the cove. Is that correct?
Yes.
Okay. And then there's also been raised whether or not the 200 feet for the water skiers, that buffer actually measures from the shore or measures or doesn't, because of another provision that I read earlier that actually identifies the shore, a 200-foot buffer from the shore. Shore was not used in this section. And so an argument has been made that there is no restriction from the shore for the water skiers. So I guess the way that I would view that is that a water skier could be using what's the proposed farm area as a buffer, that it currently is available. I think I understood that the argument to be that. So we should discuss that. What do we believe this 200-foot buffer restricts? Does it restrict water skiing from the shore? Does it restrict water skiing from the edge of the farm? Both? I'd like to hear discussion on that. Mr. Gomez.
Here I go again. In my mind, I was using that number from the shore. The 200 feet from a stationary object, I would expect would include things like the moorings and if anybody's got any lobster pots out or anything like that. So in my own internal deliberation, I considered the 200 feet from the shore, not the fixed asset such as a flag on the farm. You brought up a good point. I'm not sure whether I need to change my thinking and make it 200 feet from the furthermost stationary object in the farm. An additional 200 feet, I guess, would take it out another, maybe 500 feet from the shore or so, or maybe more, which is pretty restrictive. But again, we go back to the separation of the 5% rule and the recreational carrying capacity, which, at some point we might have to admit that the carrying capacity of that small area has been exceeded. And there's nothing we can do about that. People go and use the water. So I'm still listening to deliberation before I make a final decision, I guess is all I can say.
Yeah, I think the way that I read this ordinance is that you could, without the farm being there, you could have a water skier or a boat be in the proposed farm area if it's a start or a finish of a run, because it says, except as may be incidental to starting or finishing a run. So the way that I view it is just assume that it is 200 feet from shore. Just assume that interpretation. The boat and the water skier can still be there if they're, getting ready, they're starting up the boat or finishing the boat. Or, they're finishing their run and another water skier comes in, they can be in that area, just to get out of the water type of thing. So to me, that is clear that they can be in the proposed farm area depending on what the activity is. They can't be in there for full throttle potentially, but at the beginning and the end. Does anyone disagree with that? Okay, and then this setback, the 200 feet, is not, let's assume that it's from shore. It doesn't relate to other activities. Do we all agree on that? This is water skiing specific? So that the other activities we've talked about with kayaking and paddle boarding and sailing and whatever, something other than the water skiing, you can be within the 200 feet from shore, assuming that's the interpretation. Does anyone disagree with that?
No, Madam Chair, and if I may, that's the, the plain reading of the ordinance.
Okay.
It applies to one activity, but not others.
Okay. And then we also have this subpart 6, no person shall operate a personal watercraft within 200 feet of swimmers, divers, shore, or moored vessels except at headway speed. So I think that's pretty clear that personal watercraft, I don't know if that's more than jet skis. It's defined in the ordinance as jet skis, etc. So I know it applies to jet skis and they can't be within 200 feet of shore under this. And except if they're, I guess, slowing down and just getting out of the way, out of the fast lane. Does that seem like a reading, Mr. DeSisto, that you'd support?
Yes. And I'm not going to say I'm an expert on personal watercraft, but I don't know what it would encompass other than the jet skis.
Yeah. Okay. So, Ms. Reynolds, I know you were talking about the buffer before. In this discussion, does that change any of what you were saying, or is that how you understood the buffers to work? And again, this is my interpretations. I'm happy to discuss anything.
No, it does. I was thinking that it was also from the shore as a stationary object. So it does sort of open up the level of impact for, a different interpretation of those buffers does allow for impact from the proposed farm. And I also, as part of this too, I want to talk to Ray's issue of safety. And so when I think about that, obviously safety is a really important component to just any kind of law or ordinance. And I'm thinking about the category B ascent requirements where it mentions that it needs to be, it's D where it talks about that it's applicable to all safety codes. But a lot of what we heard, and I know that the people who live on the pond are recognized as sort of experts in their area. And so their testimony about safety was really important and relevant. But did we hear anything? I'm trying to remember from anybody about any, from sort of a harbor master kind of person, if there's somebody like that actually could testify to safety issues. Because I do think it's important, but I'm not sure how to weigh that in consideration of these ascent requirements.
Yeah, I mean, and that was brief. The harbor master did comment on it, and I'm paraphrasing, and he said that he didn't view there to be safety issues. And then weigh that against the Waterfront Advisory Commission that said that there were. And so in my view, it's not clear that there was a expert specifically on safety. There were experts on both sides that I think commented upon that. But just to answer your specific question, the harbor master did comment on it.
Madam Chair, not talking as an expert in this area, but I have taken a number of boating classes with the state, with various grandchildren and friends and things. The jet ski issue, state of Rhode Island, you cannot operate a jet ski without having get a safety certification that you are qualified to operate such. And the same is true with a high-speed motorcraft and skiing and things. So all of these people have to have a safety, have to have passed the course relative to operation of those recreational platforms and safety with them. So, the safety issue theoretically is supposed to be ingrained in the people And, you know, running a jet ski through an oyster farm or something like that, or running it too fast along the shore and things like that is kind of a prohibited activity from a safety standpoint, in accordance with the boating courses given by DEM.
Okay, yeah, and I did note that, you know, looking at the full ordinance, that there were such requirements for operation of motorboats and jet skis. That's consistent with what I saw in the ordinance. Mr. Koya.
Thank you, Madam Chair. Talking about the delineation of the markers and the 200-foot buffer, my rationale in interpretation was that it's 200 feet from the closest fixed object, which would be something that's in the field, the aquaculture field or farm. And that's why I said that I think placing it there compresses the activity more towards the middle. And, you know, there's been some discussion about fishing, kayaking through the farm. But my concern is more of a high velocity physical movement, i.e. a person on skis and or the vessel pulling them. And I don't know about everyone else, but I learned some physics of water skiing during this this whole hearing about the arc of the curve that it makes. You know, the boat can turn this fast, and I'm going like that, people could see me, but the skier does a much bigger tail. And because of that, the driver and the skier has to be cognizant of the area that they can operate within. So again, my concern is on the safety, especially with the water skiers, because of the velocity in which they're moving versus a kayaker. Not to say that you know, someone can't get hurt kayaking if something happens, but my safety concerns are more of the moving vehicles and the moving person being pulled. And as I said, I think obviously prohibiting them, and there's a prohibition, but there's also a common sense prohibition for them to water ski throughout a aquaculture farm. You're putting them more towards the middle so that when there are other skiers there, and there has been testimony that there has been more than one at one time, there's now more of a chance that they're in each other's way. So that's my rationale for that. So in a long way, my interpretation is that it's 200 feet from a marker or the delineation point in the aquaculture farm.
I do agree with you that I think that's the way to read the buffer. It's a moving or stationary object. So we know that the proposed farm does take up the 200 feet of the buffer, and then it goes a little bit beyond that. So 75% in the buffer, 25%, I think I'm stating this correctly, outside of the buffer. So go outside that 25% and then measure from there 2 more feet into the cove. And there were some depictions of, I think, Mr. Whitney's report of what that would look like. And then, you know, so there was buffers around the farm, 200 feet out. It also looked at work boats being parked there, those being also stationary or moving objects that you'd have to measure 200 feet from. So that would be additional bump outs where those boats are parked. So I agree with how you're viewing it. That's how I viewed it. And I think with respect to the skiers, there's been much debate on whether or not the elimination of one of 2 or 3 years is significant. And it's a small number, right? But it also is, if it's two, it would be a 50% reduction in that activity, that only one skier would be able to do the run at any given time. There was discussion about how, people park and wait so that they can get in a run after someone else is finished. So you've eliminated one from, two being able to do it simultaneously, and you also have those waiting. So I think cumulatively on any given day, if you have 8 hours of a day and then you have 7 days a week during the summer season, that could result in hundreds of skiers not being able to ski in the cove, even though it's just one at any given time. But I think cumulatively it's a bigger impact. I also think that the more passive recreational users will get pushed more towards as what's been referred to the meaty middle, outside of the farm, more in the deep water area. They can go around the farm. We've had testimony about that there's going to be at its narrowest point 10 feet. So they could go around the farm near the shore. But would they, or would they feel uncomfortable with that? I don't know. I think practically it will put more into the middle. And I don't think you'll have passive recreational users, based on the testimony that I've heard, going through the farm. There are, I guess you could navigate through the farm, but I haven't heard, anyone in this proceeding indicate that they would be comfortable doing that, because they could fall or the wind would blow them and they don't want to get caught up in gear or lines. So I think, the combination of bumping out the buffer zone, assuming that would be in effect at the time the farm is constructed, and then shoving more activities into the smaller condensed area does present a significant impact that I can't see it any other way, really, because of the condensing of the space and the testimony about the deep water being at a premium, two areas of the pond, the northern basin and Seeger's Cove. And so it's not like there's 97% more of the pond to use for water skiing. It's just two places. And the northern basin is already crowded with skiers. So I do think cumulatively there is an impact on existing uses that, if constructed, it would be significant. And I agree, I think it poses safety issues.
Chair. Yeah.
Mr. Gomez.
Yeah, you mentioned work boats. They're there on a temporary basis and they probably could be scheduled. The applicant could probably schedule those to be away from peak hours when people would be skiing. But if you're going to do the 100, 200 limit on, the flag that's set out in the scallop area, you've got rafted boats during the summer, especially around the 4th of July weekend, Labor Day weekend. You've got anchored boats that sometimes anchor for fishing or cohogging, sailboats moving extremely slow or stopped. Even bass fishing, as people have mentioned, it's great bass fishing water. People normally drifting for bass fishing. Those are all stationary objects. And you start putting the 200 foot around them and you shut down the whole cove. So I think we can carry this to extremes. And again, getting back to the fact that maybe the recreational use has gone past its carrying capacity. And that's why I question the separation of the farm from the recreational. So I'm still there and still thinking, but you've made some good points. And safety issue, when I went through all the material, safety issue was the first thing I wrote down. And I did consider the 200 feet from the shore, and the idea that you lost one skier at a time. It seemed to be the math. That's the way the math worked. And that did not seem significant to me, but I'm not a skier. I'm a fisherman. So those are my points.
Okay, Mr. Koya.
Just to follow up on that, I think what we need to take into consideration and focus on is that the existing use right now is the recreational. That's there. It's been there for a long time. So the applicant is now looking to inject an aquaculture farm into an area that already has an existing use. So I know Don said, well, maybe the recreational use has, I forget what he said, like maximized
Yeah.
or that. But to me, you can't take it away. We're not adding recreational use. We're not putting more boaters there. We're not putting more skiers there. We're trying to protect what's already there. And I think, again, I keep going back to the language of our standard of review. Is there a significant impact? And what you have to look at, well, what's there? How's the use current? How's the use been for the last 50 years or however long? And then would the addition of this farm have a significant impact? And that's how I'm looking at it. I'm looking at what's already there. And with the evidence that showed all the uses that everyone has been doing for all the years. So just wanted to follow up on what Don had said.
Thank you. Mr. Murray or Ms. Reynolds, would you like to comment on any of this? Ms. Reynolds, you're on mute.
Sorry. I'm thinking back to when we did the review of the dumplings, and one of the things that we sort of talked about was a balance of uses there. And you look at the proposed aquaculture and what we've all agreed is a very conservative limit on aquaculture in the total pond at 5%. And the fact that the pond still falls below that 5% with the addition of this new 3-acre farm, does that sort of talk to the balance of uses? And when I think about the potential impact to the recreation from the farm, so it's the towed water sports is a subset of sort of the total recreation package. And so I still, I don't think that the limit on the water skiing or the tubing in that specific area is a significant impact. But I do think danger to even one person skiing in that area is significant. So if we do interpret that buffer as being something that needs to be extended for safety, that would definitely factor into how I start to think about the safety issue. And that for me would sort of trump all of the other things.
You know, I just point out that the ordinance, again, it's not a CRMC requirement. We're not, you know, looking at this and checking off the box and saying, is it met or not? We are just looking at it as assuming that it is enforced by the town. What does it do as far as conflicts with existing uses if the farm goes in? So just want to make that clear. But I agree, you know, that water skiing is just one subset, and there's some debate, as I'm hearing, as to whether or not the impact would be significant on water skiing. But just take into consideration that the other uses, they're not going to be displaced entirely, but they will somewhat. They can kind of hug the edges by the shore, or they go on the other side near where there's the water skiing. They don't have that 3 acres unless they want to navigate through the farm. They, you know, and they likely won't do a lot of that. So all those uses are not going to be, I think someone described it in the testimony, they won't be in the slow lane. They won't have that slow lane anymore. And then the water skier is the deeper water. So you have the slow lane and the fast lane being put into one more narrow space. And these town ordinances, or the Waterways ordinance is, you know, the 200 feet, that's a safety ordinance. So presumably it's there for a reason, right? To keep people away from each other. And again, you know, the water skiers have to stay 200 feet away from, you know, from others. Jet skiers have to stay, you know, there's so many things to maintain a buffer on, and then you're putting them all in the same place. So the overall activity that can occur in the reduced water sheet becomes much smaller. Because if you have water skiing there, maybe you're not going to have much of anything else, unless those more passive recreational users want to go along the more kind of narrow edge of the shore.
Madam Chair,
Yes, Mr. Moore.
I think Ms. Reynolds raised some very good points about balance of use of the public resource. Although I would, you know, concur that the safety issue is a thorny one, and even one injury would be too many. So it's kind of hard to get by. I have a wonderment about, or a question in my mind about 3 acres is the max. Is that indeed the maximum size of a lease that can be sought?
Yes.
Yes. And just throw this out as a question, a reduction in the size of the farm mitigate appropriately the safety issues that have been raised? Although there was no indication of any accidents per se. Wasn't that question asked during the course of the hearing? And there were no reports from DEM regarding people being hurt or what have you. And so I just wonder.
Yeah, I mean, I think the answer, this is kind of a lawyer's answer, but it depends. It would depend on the resulting size. It would depend on the configuration, the resulting configuration. I don't know what you're proposing, but
I'm not proposing anything. It's a question I have in my own mind. Because you look at the two configurations, the rectangle or the polygon, and I think the polygon was, I guess, an effort in some respects to try to accommodate some of the concerns that have been raised in the initial travel of the application. I do think, you know, 10 feet to shore is too close in my mind, but you know, there's been a lot of length to this, and I guess there's good reason for that. I don't have a magic answer to any of the questions that are lingering.
yeah, understood.
Madam
Mr.
Chair, I think we do need to remember that half of this farm is submerged underwater, no floats on top, with the exceptions of the mandated anchors at the corners. So, yeah, we're talking 3 acres, but the deep water part of it is all submerged, and I'm not sure if the application restricts it to submerged for scallops, but I mean, that would be one of the stipulations I think we could put on a permit, that there'd be no floating bags out in the outer half, if you will, of the pond. The 10 feet, I had considered maybe eliminating one row along there, because I agree that 10 feet is not a very significant amount of space, especially even with a kayak or something. And if you eliminated one row along the shore, you'd get more distance. I do think that the 10 feet is from mean low water, which only occurs for a small portion of the time. So therefore it is greater than 10 feet for the majority of the tidal cycles. All of that comes into play. So we start talking about, very small pieces of this puzzle. And I'm not sure. And again, I'm really concerned about safety myself. I don't like to see problems, but I've spent my whole life at Secundit Point going around traps and around lobster pots and nets and gill nets and things like that. Sometimes they're mocked, sometimes they're not. And it's just something you have to deal with and get used to. And I don't see a 3-acre farm, half of which is submerged, is a real big problem. But again, understand the safety aspects. And we're in a mindset that even though these people have certified safety certificates to operate, doesn't mean that they follow them. The town has ordinances. I guess it doesn't mean they follow them. So foolish people end up in a jam sometimes. And again, those are just things going through my mind to deliberate the final outcome.
Yeah, I mean, they either won't follow them or they will follow them and it'll just eliminate a lot of activity. So that's, they're either not going to observe it and there'll be a problem, or everyone will observe it and then it, you can't do a bunch of things that you used to do on the cove, or somewhere in between those two.
I think in between. Yeah.
But maybe, Mr. Gomez, we can ask Mr. Butel just on the submerged part of the proposed farm. Can you describe how deep that's submerged and what the infrastructure is in the submerged area? And I guess that's just the scallop area with the suspended gear. And yeah.
The proposed scallop gear was suspended lantern nets. So that would require buoys on the surface of the water to suspend those lantern nets. It appears to me that there would be 3 to 4 feet of water above the top of the lantern net.
And how many buoys are required for that?
It depends on here's a lawyer answer. It depends.
Okay.
It depends on the weight in the lantern net. So as the scallops grew, additional flotation would have to be added. It may still be 1 float per lantern net, but the size of the float would be increased.
Okay. But you wouldn't be able to get rid of the buoys because you'd need that for the scallop infrastructure to grow them. You can't get rid of the buoys that supports the whole thing.
Yes, you have to be able to access the lantern nets.
Okay.
You could put a buoy in the top of the lantern net so that you didn't see it from the surface, but then your ability to access it would be diminished.
Mr. Gomez, does that answer some of your question on the submerged portion?
Yeah, it even makes it more complicated for me.
Yeah. Any other questions about the infrastructure that would be required for this farm? And just to clarify, Mr. Butel, the outward edge or edges of this farm would have infrastructure on them, right?
Correct. The corners or Yes, the corners should be marked.
So it's a stationary or moving object, I guess stationary object.
It should be anchored. It shouldn't move except with the tide and wind, but the anchor part shouldn't move. The float part will.
Okay. Is there anything else that we want to discuss just about Seeger Cove? Yeah, how it's shaped, how it's used, how it compares to other areas of the pond that's relevant to our discussion here? Do people believe that the testimony was clear that the uses typically happen in the middle of the cove as opposed to where the mooring area is in the south, or the very north where you have the docks? Does everyone view it that way? Mr. Murray?
Yes, generally speaking. I mean, the mooring areas are much shallower, and so the deeper portions of the cove are, it's relative. It's, based on a chart I've got, this 5 or 6 feet of depth in the more active area of the pond, of that port of Seeger Cove. That is.
Anyone else want to comment on the geography of the and features of the Seeger Cove? Before we go through the category B requirements, does anyone want to talk about any other evidence that came in that would relate to any of these requirements that we need to make a finding on?
Madam Chair, I just wrote down, I had written down just two other areas that popped up a lot. One was noise and the other was pollution. I think we all agree that pollution is not a problem. The noise impact, I didn't see as a problem either. I'm not sure we need to get into deep discussion on it. I just presented as two more factors that came up during all the presentations, noise and people indicating that there would be pollution there. So that's the only reason I mention it.
Yeah, and maybe we discuss this when we go through the category B requirements, but I agree with you that I don't think that there's a pollution problem that's proposed that would be caused by the proposed farm. I think any noise issues that could be caused by the farm can be controlled through operational control. So I know the applicant had proposed, not using tumblers or power washers or radios and having restriction on hours, and all those things I think would eliminate some of the more odious aspects from a noise perspective of a farm. I was gonna, depending on where I ended up, I was gonna propose also, no tours that you bring from the restaurant, that type of thing. So yeah, I didn't see those as impediments.
Thank you.
Madam Chair, I just wanted to ask about that also. So I thought as part of the public testimony, there were some people that got up in favor of the farming, the aquaculture. And one person actually, he got up and he said that he preferred it because the amount of noise and pollution from the boats and the water, the existing motorboats there, he thought sort of outweighed the impacts of the farm. And when I look at the ascent requirements, mostly it talks in terms of potential negative effects of the farm. But how do we factor in the evidence that we heard about the fact that the farm actually cleans the water and weigh that against, you know, extra pollution created by recreation? Is there a balance between that, or do we not consider that?
I mean, I think we can consider, you know, what the existing pollution might be in the cove. And when we go through the category B requirement about, you know, impact from the farm, I think that can be considered at that time. Does it help clean up the pond? And so if it both reduces activity and takes away, you know, some of the pollution because they're filter feeding organisms, then that goes into that factor. I think that's the answer. Mr.
Okay.
Does that sound right?
It is. It's definitely a factor that could be considered on this. Under category B.
Okay. All right. So let's go through the category B requirements. Okay. The first requirement is to demonstrate the need for the proposed activity or alteration. And so what I'll do, I'll just go around to everyone. I'll start with A and just get your feedback on that. I do think that the applicant has demonstrated a need for this operation, that he's maxed out on his existing lease and wants to grow the business. And I think that's a threshold that is, you know, not it's a low threshold, but it's an easy thing to meet, particularly where you have a maxed out existing lease. And I think the policy behind that is to ensure that it's not a speculative type project. And I'll just ask any one of the staff if you would comment on that, if I'm wrong on that, but that's how I view it. Any Mr. Getz or Mr. Butel?
I would agree with your assessment that his current farm is maxed out. He had tried a number of times to expand the current farm in its location, but the rules about eelgrass have prevented that location from being expanded, and hence his desire to move into Secret Cove.
Okay.
So he has met that burden.
Thank you, Mr. Butel. Mr. Koya, any further comment on need?
Chair, the way I looked at it was, and I've even got notes I wrote down, you know, need versus want. Is it something that's needed by this individual? Is it something that's needed by the public? Is it something merely the applicant wants? I have absolutely no disagreement that he's maxed out where he is. So then the question is, all right, then does he need it because he wants it? And does need apply to this particular parcel? You know, a lot of times when we talk about need in our standard of review, it's a property owner and they want to do something on their property. And obviously they need it there because that's their property. They can't walk somewhere else. So maybe unlike some other individuals, I'm looking at it that this is not his property per se, and he's looking to go put it there. So yes, he needs it to grow his business, but is it needed to be there? And that's part of my deliberation. You know, is it a want versus a need? And then you know, who benefits from the need? So that's where I was going with it. You know,
I mean, I agree that he wants it. I mean, of course, he's applying, and I don't know if it sounds like it's more subjective in your mind as to what need is, and you don't know if it's related to the particular farm. Either Mr. Getz or Mr. Butel, can you shed any light on what we evaluate when we look at need? Mr. Butel, you already addressed it. Mr. Getz, do you have anything further to add?
I don't think so. I think Mr. Butel's comments, you know, if it wasn't for some of the restrictions around eelgrass, I think the applicant would have applied to expand his current operation where it is. Because of those restrictions, he needed to apply elsewhere.
Thank you. Mr. Murray.
I would agree that with the chair's perspective that he's met this standard.
Ms. Reynolds?
I agree that he's met the standard, and in thinking about want versus need, definitely he's a business person and he wants this. But I think that overall, I'm looking at it a bit more globally. I think that we need to be able to produce food, and we need to be able to provide jobs. So I think it benefits not only Perry, but it also benefits us as a community. So I think that he's met that standard of need.
Thank you. Mr. Gomez?
Yes, I agree with Ms. Reynolds. Going back to the Red Book, we do promote aquaculture quite extensively at CRMC. I think this is an extension of that. I think the need has been met, and I think he's met the requirement for need. The other issue is getting back to the idea of balance, and it appears that if we deny this application, then the idea of balance goes strictly to the people that want it for recreation and view sheds. So yes, he has met the need.
Okay. All right, moving on to 1B, demonstrate that all applicable local zoning ordinances, building codes, flood hazard standards, and all safety codes, fire codes, and environmental requirements have or will be met. And then it talks about local approvals. I don't think there's any issues here of applicable. There's local waterway ordinances. I don't think that the proposed farm would be inconsistent with that. It would just be subject to it. Mr. DeSisto, is that a correct way to view it?
It is, yes, because that ordinance regulates actually another use other than this one. And the ordinance couldn't regulate this use because by state statute, authority to regulate is conferred on CRMC and not the local communities. This is what I was referring to earlier in this meeting. This standard goes to those codes that are more for upland uses as opposed to water uses.
Right. So it would be an inapplicable requirement.
That's correct, yes.
I would add that it does mention 1.3.1K, and that is specifically with regards to freshwater aquaculture conducted on land. We have this as a prerequisite for application to CRMC for an assent for freshwater land-based aquaculture.
Okay, and that's what it's meant to address.
I believe so, yes.
Right. I'm just going to ask if all agree that this is not applicable to this proposed farm. Mr. Gomez?
Yes,
Ms.
I
Reynolds?
agree.
Okay, thanks. Ms. Reynolds?
Yes, I agree.
Mr. Murray?
I agree.
And Mr. Koya? Mr. Koya?
Yes, based upon the evidence that I've reviewed, I agree.
All right, moving on to 1C, describe the boundaries of the coastal waters and land area that is anticipated to be affected. I believe that that requirement has been met through the application materials and the testimony provided by the applicant and his experts. Mr. Koya,
I concur.
Mr. Murray,
Just a question. There are two concepts. Are we talking about the polygon or the rectangle?
yeah. I guess we have to be talking about both. I mean, the applicant, the initial
They've been,
rectangle, and then there was an alternative that was developed with staff for the polygon. And both have been depicted in our application materials.
yeah, I agree. So, but I understand the polygon is preferred, so-called, by the applicant at this point.
I think the polygon is preferred by staff. I don't know where the, I thought the applicant preferred the rectangle, but would be okay with the polygon.
Okay, back in geometry class, I guess, right?
Right. Ms. Reynolds,
Yes, I agree.
Mr. Gomez.
Agree.
Okay. 1D, demonstrate that the alteration or activity will not result in significant impacts on erosion and or deposition processes along the shore and in tidal waters. I believe through the testimony provided by the applicant that they've satisfied this. There's no issue here, and in fact, I think it could actually help prevent some erosion by breaking up the waves generated by various activities on the water. So I think that this was satisfied, that there would be no significant impacts. Mr. Gomez?
Agree.
Okay. Ms. Reynolds?
Agree. The applicants met that requirement.
Mr. Murray?
Agree.
Mr. Koya?
I agree. I think the applicant has met that burden, and I don't recall or have a recollection of any contradictory evidence by any of the objectors that would dissuade that.
Thank you. 1E, demonstrate that the alteration or activity will not result in significant impacts on the abundance and diversity of plant and animal life. As I recall, DEM indicated that there would not, that the impact here would be minimal. There was also the Fisheries Council that was split. There was some that they believed would be an impact and some that did not. And cumulatively, and in addition, combined with the testimony of the applicant, I don't believe that if there is an impact, that it has risen or it would rise to the level of significant. That's my view, and that this criterion has been satisfied. Mr. Koya?
Madam Chair, I believe that the evidence submitted by the applicant would support that he has met that criteria.
Mr. Murray?
I would agree as well.
Ms. Reynolds?
I would agree as well.
And Mr. Gomez?
I agree.
Okay. 1F, demonstrate that the alteration will not unreasonably interfere with, impair, or significantly impact existing public access to or use of tidal waters and or the shore. Okay, I want to have a little bit of discussion on this because it appears that it's it's twofold. So it talks about significant impact on existing public access. And then it talks about significant impact to existing use, which is kind of like J, that has us evaluate whether or not there's significant conflicts with water dependent uses. So I see it as a little bit redundant of another criterion, but it does have this additional, I guess, evaluation of whether or not it's impacting public access to the tidal waters or shore. And so I'm just going to speak to the public access part of it, and then I'm going to combine the use of the impact on use when we talk about the conflicts criterion. So for public access to the tidal waters or to the shore, I do, there are public access points. They're not in the area of the proposed farm. So that's not impacted. It does restrict some of the access in the area where the farm hugs the shore, but it doesn't entirely impede it. So in my view, based on that, I don't think that there's a significant impact on public access. Mr. Gomez?
I agree with that. I think the word unreasonably is, it states that it in fact is reasonable. I would agree that it does not present a detriment to the public access.
Thank you. Ms. Reynolds?
I agree that it does not significantly impact public access
Mr.
or
Murray?
unreasonably.
Sorry. Thank you.
Sorry.
Mr. Murray?
I would concur that it doesn't unreasonably interfere with access to the shore, although I had noted earlier, I thought the 10 feet was kind of I guess the eastern side of the proposal.
Yeah, I agree. It makes it a little more difficult in that area, but overall not unreasonable in my view. Mr. Koya?
I would be of the opinion that there is an impact, but I do not believe it to be a significant impact.
All right, 1G, demonstrate that the alteration will not result in significant impacts to water circulation, flushing, turbidity, and sedimentation. Based on the expert testimony that I heard, I believe that this burden has been satisfied, that there would not be a significant impact posed by the proposed farm to water circulation, flushing, turbidity, and sedimentation. Mr. Koya?
Madam Chair, I agree. I don't think there was any evidence put forth that would be contradictory to that.
Mr. Murray?
I would agree as well.
Ms. Reynolds?
I'm in agreement as well.
Mr. Gomez?
Yes, I agree.
1H, demonstrate that there will be no significant deterioration in the quality of the water in the immediate vicinity as defined by DEM. Again, I think there was a lot of testimony put forward that the proposed farm would actually have the effect of improving the water quality. I think it's even stated in the Red Book. It says in K1A, the CRMC recognizes that responsible shellfish aquaculture has a net positive effect on the environment. That there's been some determination already by the agency that that aquaculture improves the water body. Um, and this particular proposal, I don't think is any different. I think it's consistent with that general finding and based on the evidence submitted. Mr. Gomez?
I agree. No significant degradation to the water quality.
Ms. Reynolds?
I agree that there's been adequate science on the fact that aquaculture positively impacts water quality, and that it could also potentially positively have an impact on the diversity of plant and animal life.
Yes, that's true. Got that too. Mr. Murray
I would concur with that point of view.
and Mr. Koya?
Madam Chair, I would concur and state that I believe the evidence put forth by the applicant supports that and reflects that he meets that criteria, and that there was nothing put forth by any objectors to contraindicate that.
Mr. Butel, just a question for you on this point, because this criterion does talk about as defined by DEM. I know that there's a letter from DEM that says minimal impacts. I don't know if it goes to quality of water or diversity or abundance of plant and animal life. Could you comment on that?
Yes, I can. There's a letter from the DEM Office of Water Resources that comments on the water quality. And that letter says that the water quality will not be negatively impacted.
And what exhibit is that? Or
I don't remember. It's in the packet.
okay.
Um,
And you reviewed it and were satisfied that was the as defined by DEM for purposes of this criterion?
yes.
Thank you. And does anyone disagree with that as explained by Mr. Butel? Okay, hearing none. All right, on to 1I, demonstrate that the alteration or activity will not result in significant impacts to areas of historic and archaeological significance. There is a letter in the staff report that is from the Rhode Island, I forget the acronym, but Historic Commission, I'll just shorten it, that essentially speaks to this point that there's no historic or archaeological significance with the area in which the proposed farm would go. So based on that, I would say that this is satisfied. Mr. Koya,
I concur.
Mr. Murray,
I would agree.
Ms. Reynolds,
I would agree that the letter from Rhode Island Historic Preservation and Heritage Commission indicates that there is no negative effect on historic resources.
thank you. And Mr. Gomez.
I concur.
All right. 1J, demonstrate that the alteration or activity will not result in significant conflicts with water-dependent uses and activities such as recreational boating, fishing, swimming, navigation, and commerce. Okay, this is the burden that the applicant has that we've all been talking about previously. What are the existing uses? How will the proposed farm affect the existing uses? And as I've stated, I believe that there will be significant conflicts with existing water dependent uses for everything that I explained earlier. And I don't believe that the applicant is able to satisfy this burden because of a combination of the town buffers, 200-foot buffers, which get measured from either the shore or from or the stationary or moving objects, and condenses a multitude of activities in the center of the cove, and presents, in my view, unreasonable and too significant of conflicts. Mr. Koya.
Madam Chair, I would like to incorporate all of my prior comments so I don't reiterate them in this, but I too am of the opinion that I do believe there is a significant impact. It pushes everything towards the middle, and to me, that's where a safety concern arises. So this one is the one so far where I feel the applicant has not met his burden in our requisite criteria.
Thank you. Mr. Murray.
I guess this is the thorniest of the criteria. And it's kind of a gray thing to, I mean, the safety issue that's been discussed this morning, or the potential safety issues, I think are perhaps rise to the level of significance. So, or could rise to the level of significance. So I guess somewhat reluctantly, I would agree with the position of the chair and the vice chair.
Okay, do you want to have further discussion on it?
Well, it seems like at least 40% of the die is cast, so to speak, and the position's taken. So I'm not sure if discussion would lead to clarity. So it's a potential issue, and safety is an overriding concern with any regulatory consideration for permitting or zoning or land use or water use or what have you. So I guess it's an issue. So.
Okay. Thank you. Ms. Reynolds.
So I agree with Vin. This is, where the rubber sort of hits the road. And I think, I don't think based on the evidence presented that there is a significant impact, but I do think that the safety issue is paramount. I do have a question about the interpretation of the zoning ordinance. Is that how the zoning official for South Kingston interprets that boundary, that it's from the farm? Do we know that? Or does the zoning official interpret it from the shore?
Ms. Reynolds, I'll let Mr. DeSisto speak to it, but I don't think we have that interpretation that's before us. But I think that the language is clear. Let me just read it one more time. No, and this relates to water skiing. No water skier or his or her boat shall approach any stationary or moving object closer than 200 feet, except as may be incidental to starting or finishing a run. So I think we heard that at least the buoys would be, that mark the edges, are stationary. So I don't know if the zoning officer would take a different interpretation, but I view the buoys as stationary, and that infrastructure in the farm is stationary. Mr. DeSisto?
Yeah, I agree with that. There's no opinion, at least I didn't see, from the zoning official on the interpretation of the ordinance. or any official from South Kingston. However, I do think the ordinance is clear, and the fixed object would be the buoy, and you have to measure it from that 200 feet. And that, I don't see how any official of the town of South Kingston would interpret that differently.
Then I think that that standard is not, because of the safety issue and the fact that it would then compress the existing uses into too small a combined area of the water sheet.
Ms. Reynolds, just, you were saying something and then you went mute and then you came back, so we didn't hear exactly what you said.
All right, so then I would agree that it doesn't meet that standard, that part of that standard, because the compression of the water, I'm sorry, my phone keeps ringing. I turned it off. That the safety issue, then the fact that it would be interpreted so that it would compress the area of the water sheet would lead to a non satisfactory condition for safety.
Thank you, Ms. Reynolds. Mr. Gomez.
Yeah, I've said several times, I guess, that I'm really in favor of a balance, and I think the applicant really has no other options within the pond. From what I've seen, the other area where there's some deep water is more heavily used than this one. We are still talking about one skier, but I had based my initial thoughts on a 200 foot from the shore. And I guess I have to agree with all the other members of the subcommittee that due to the South Kingston ordinance, there is a significant impact to the conflict with other uses. And my rationale is strictly because of the ordinance. And we have to, I guess, forego balance and in this particular pond. Thank you.
Thank you, Mr. Gomez. And finally, 1K, demonstrate that measures have been taken to minimize any adverse scenic impact. As we've discussed previously a little bit, I believe that measures have been taken by this applicant that would have the effect of minimizing the adverse scenic impact with its low profile cages in particular, and a portion of the farm being submerged except for buoys. I think that he's done what he could do to minimize those impacts. Mr. Koya?
Madam Chair, I believe that the applicant has put forth sufficient evidence to support a finding that he has met that criteria.
Thank you. Mr. Murray?
I believe this criteria has been met.
Ms. Reynolds?
I agree that the applicant has met this criteria.
Okay, and Mr. Gomez?
The applicant has met this criteria.
All right, we've gone through all the category B requirements, and I'll ask Mr. DeSisto, do we need to make a finding on the 5% rule?
I'd appreciate it if you did.
Okay, all right, so as we've discussed earlier, there is a rule that the aquaculture in any coastal pond cannot exceed 5% of the total open water surface area below MLW. And I, based on the staff report and all the evidence, this criterion has been satisfied in my mind. Mr. Gomez?
I concur that the applicant is within the 5% rule.
Yeah. Ms. Reynolds?
I agree, the applicant's within the 5% ecological carrying capacity.
Okay. Mr. Murray?
I would agree as well. It's below the 5% capacity.
Okay, and Mr. Koya.
Madam Chair, I believe that the evidence submitted supports that the applicant is percent.
Thank you. Mr. DeSisto, are there any other standards that we need to review that I have not articulated and gone through with the subcommittee members?
No.
Okay. All right, so I think at this point, we're ready for a recommendation, a motion on a recommendation to the full council that will be delivered at a subsequent council meeting. Mr. Willis, when do we know when that will be?
Well, we would need the written recommendation of the subcommittee prior to scheduling it. But at this point, it's probably April at the earliest.
Okay, thank you. All right, so I will entertain a motion. Mr. Koya.
Thank you, Madam Chair. Based upon all of the evidence presented on both sides by the applicant and the objectors, and applying all of that evidence, expert testimony, lay testimony, demonstrative evidence, scientific evidence, to our requisite criteria, as we just enumerated, going criteria by criteria, I believe that the evidence finds and supports a finding of a significant impact on the water use, existing water use, recreational, and to use, incorporate the exact language in my motion. And as such, I believe that because of this finding, that there is a significant impact and that the applicant did not meet that criteria, it is fatal to the application, and I would move to make a recommendation to the full council that because of that, that the application not be approved and be denied.
Thank you. Is there a second? I'll second the motion. And I will do any further discussions before I do a roll call. Okay, Mr. Koya,
I vote aye on the motion.
Mr. Murray,
I would vote aye on the motion based upon the issues relating to criteria J under the category B assent requirements.
thank you. Ms. Reynolds,
I would vote to approve based on issues of safety concerns.
approve the motion.
Approve the motion.
Mr. Gomez,
Move to, I will support the denial of the application due to significant impact, conflict with other uses of the water.
okay. And for myself, I vote aye in favor of the motion based on the failure of the applicant to carry the burden on 1.31A1J. So based on that, we're unanimous. The motion to recommend denial carries. And Mr. DeSisto, you're going to prepare a written recommendation to the council.
That's correct, and I'll work with staff on that, Madam Chair.
Okay. Is there anything further that we need to do?
My only question is, once the recommendation is, the written recommendation is prepared, will it, can it be forwarded directly to the full council, or would this subcommittee like to review it first and pass on the written recommendation?
Anyone want to comment on that? Subcommittee members? Do we want to look at how it's written up before it gets transmitted to the full council.
Madam Chair, I would not object to getting a reading on it, but I will concur with other members of the subcommittee on what they wish to do.
Thank you, Mr. Koya.
Yeah, I would just like to look at it quickly, just to make sure, I think due diligence that we should, to make sure that it correctly depicts our findings.
Ms. Reynolds,
I agree. I'd like to take a look at it first.
Mr. Murray.
Yeah, why not cap this process off of great length and breadth? I'll take a look. That would not require another meeting, would it not? Would it be a review and email if there's any comments or what have you, or what would be what's the story on that?
Well, actually,
Right?
yeah.
I-
I don't think it's going to take long, but
Right.
would have to be done publicly.
There would be another meeting? Okay.
It probably wouldn't be a 3-hour meeting, but
I imagine it wouldn't be, but
okay. Yeah, I would like to take a look at the written recommendation. So I agree with everyone. So it sounds like, Mr. Willis, we have a couple of steps. First writing up the recommendation, then us considering that at a further subcommittee meeting, which I guess would be a continuation of the workshop.
That's what I would recommend, Madam Chair.
Okay. And then whatever we come up with or approve at that meeting, that they would then be forwarded to the full council at a meeting that might be then in late April or early May. And sounds like it'll push it out a little.
Correct.
Okay. Anything else from Mr. Willis, Mr. DeSisto?
No,
Just
Madam.
a question.
Murray?
When this matter goes before the full council, is it required that myself as representative from the town be present for that Zoom meeting, or?
Madam Chair, I can answer that.
Please.
Yes, Mr. Murray, your attendance and presence is required through the vote.
Okay.
And what we're going to try and do, Mr. Murray, is figure out a way to make it so you have to go to all of our Zoom meetings.
Well, thank you for that. Retirement was too comfortable for me, apparently.
All right. And just to clarify, Mr. Murray, he won't vote with the full council, but is that true? He's not voting with us, or he is voting with us?
I believe he is, and I would defer to legal counsel on that. But the way the statute reads is that the alternate member, when there is no one representing the town in a contested case, sits through and take into the vote of the full council.
Okay, so if there's
Correct, yes.
8 of us, then it will be, for this particular application, we will have 9.
Correct.
voting.
Yes.
Okay. All right. And you're in, Mr. Murray.
Well, volunteerism is often punished, apparently, so.
All right. Well, again, thank you everyone for your time, for the applicants and interveners, excellent presentations and post-hearing briefs, and for all the public comment on this. And if that's all, then I will move to adjourn if I can get a second.
Don't we need to continue it? Do we need to vote to continue the workshop or no?
Mr. DeSisto?
You can, it's not necessary. You can if you want,
Okay.
but you
Okay.
can't
No,
continue it to
we'll
a
let
date.
Vin go home early. No motion.
Okay. All right. All right. All those in favor to adjourn, say aye.
Aye.
I
Aye.
Thank you, everyone. See you soon.
Take care now.